Any mention? Item number 1.
Your Lordship, in this matter, Your Lordship has appeared on...
Yes, before any other bench, without one of us bracket for attention. Yes.
Your Lordship.
Item number 2.
Yes, Mr.
My
Chandra.
Lord, I pray for some time.
Why?
Not keeping well. My Lord.
Not keeping well?
Some eye problems are there.
Oh, that's very serious, yes. Take care of your eyes.
Let it come up 4 weeks, my Lord.
4 weeks, Mr. Devan. Mr.
My-
M. Chanda, learned counsel for the appellant. Please, due to personal difficulty, the matter be adjourned to 4 weeks. Prayers allowed. Just after 4 weeks and so on. So. Yes.
Deeply obliged, James. Deeply obliged.
2 minutes. 1 minute. 1 minute.
Any mention?
May it please, Your Lordship. Your Lordship, I beg to mention item number 28, Your Lordship.
Number?
28, Your Lordship. I humbly pray, Your Lordship, that the matter may be listed after 2 weeks, Your Lordship.
No urgency.
No urgency, Your Lordship.
Just after 4 weeks, yes.
Much obliged, Your Lordship.
Please, my lords. I beg to mention item number 32. The conducting counsel, Miss Ain, is indisposed. 32. Maxim.
Your objection?
32, sir. 32. 39? Not 39.
My Lord, I am the petitioner in this matter.
Your objection?
There's some urgency, but I believe Miss Hine is not in town. But it may be fixed next week.
There's a whole array of other lawyers. Next week, yes.
It may be fixed next week,
1
ma'am.
week.
Next week. Obliged.
Nice, my lord.
As the counsel for the state, the response state to be indisposed, it's a matter of 1 week.
Obliged.
May it please, Your Lordship. Your Lordship, I beg to mention item 24, Your Lordship, on behalf of K.S. Kharshing, Your Lordship, as he is not keeping well, Your Lordship.
Go for other side. Where's Mr. Yubin? You inform them?
I'll inform them, Your
No,
Lordship.
you- Let you inform them first and mention.
Okay, Your Lordship.
May I please, Your Lordship? My Lord, I beg to mention item 27. If this matter may be taken up after 2 weeks, my Lord.
Why you adjourn this case repeatedly?
It is a joint request also from respondent number 5, my Lord.
After 3 weeks?
2 weeks, 3 weeks, my Lord.
Let it be after 2 weeks, Your
4 weeks.
Lordship. 2 weeks, Your
2 weeks.
Lordship.
2 weeks, yes.
I'll oblige, my Lord.
Obliged, Your Lordship.
Also, I beg to mention item number 20, Lordship. In this case, I am to obtain some instruction, Lordship.
What instruction?
Some documents produced by the government, Lordship.
Who for the state?
Rosie,
Who for the state?
Rosie, Lordship.
Nobody.
Miss Colney, Your Lordship, she's on legs.
They'll come after 2 weeks, Lordship.
2 weeks. Yes.
Hurry up.
Obliged, Your Lordship.
Lordship, I'd like to mention item number 23, Lordship. For respondent number 5 to 7, Lordship.
Where's
Mr.
the petitioner? You inform them first. 23.
Yes, Lordship.
You for respondent number?
5 to 7, Lordship.
What's the matter about?
This is constitution regarding constitution managing committee. My lord. This is
Usual thing. When? After 1 week?
2 weeks,
2
Lordship.
weeks. No urgency.
no urgency.
Okay.
Your Lordship, items number 21 and 22 are connected and conditional.
Oh. After 2 weeks, yes.
Obliged.
What, 26 minutes, time sometime. Mr. Jahid.
Where's the Shah?
Mala.
1 week, 2 weeks, 3, 4, how much?
Mr. Jahid is ready.
Ready?
Yes, I'm requesting for time.
1 week, then. Yes. Yes.
Daily list item number 1.
Lordship, we pray for 2 weeks' time to file rejoinders.
Rejoinder to
Uh,
the contempt.
yes, my
Who's
lords.
appearing for this?
I'm appearing, we file affidavit.
Okay, miss, why rejoinder in a contempt matter?
Lordship,
Will you see whether this
my
any
instructions
any
are
contempt or not?
my instructions are that we need 2 weeks' time to file
Why
rejoinders.
rejoinder in a contempt? Contempt between the court and the contempt now, we'll see.
Lordship,
Rejoinder is not by right.
the senior
Even in
advocate,
petition.
Mr. Todi, has instructed me as such.
Mr. Todi, where's Mr. Todi? He's instructed, okay. Allow rejoinder. Unless he has 2 weeks time aspirate for rejoinder allowed. Yes.
Item number 2.
May it please the Lordship. Lordship, I had prayed for time in this matter to file affidavit of service on the respondent number 4 and 5, but the petitioner's son met with an accident and he could not come to sign the affidavit, my lord. The condition is still a little bit serious, so I pray that 3 weeks' time may kindly be granted.
Where's the other side?
Lord, the stage is there and Mr. Day.
1, 2, 3 represented. 4 and 5 need no other respondents. Any other respondents?
No other respondents. No other respondents, Lordship.
Okay, Ms. P. Agarwal or Dr. P. Agarwal, Leonard Counsel petition submits that as the petitioners, as there is some mishap in the family of the petitioner, 3 weeks' time be allowed to file his service affidavit. Accordingly, this matter to 3 weeks, yes.
Lordship, item number 3 and 4 are also connected. It's the review petition arises out of the same judgment.
Item number 5.
Yes.
Lordship, in this case, I'll be required to file my additional affidavit because state has given some affidavit and it is contradicting operation. So,
What do you mean contradicting? Which way?
because Your Lordship, they are shifting all the burden to us as a NHDCL. But in fact, in this land acquisition matters, we are only to make payment to Kala, not other than this. So we cannot.
See, it is not a question of payment. It's a question of, in the course of your construction, whether you've destroyed, the water sources and of these cultivators. That's all.
That's all. But here, Your Lordship, this state's stand thereof that I have done something beyond of this whatsoever they have done. So regarding these matters, earlier I have given simple affidavit. So all the materials I have to brought before this court. Just we didn't do anything.
Yes, Mr. Shawwan.
Actually, in the affidavit which they have filed, my lord, they have made contradictory statements in
Who
their
has
own
made the
affidavit.
state of the union?
The Union of India, my lord. First, in the paragraph, they said that they have never, they do not know us, they are not aware that we are also the beneficiaries of this compensation. If I may take your lordship to...
No, just submit because he's asking for time.
Right.
Is it necessary? Or we can proceed with the materials that already...
Because later on, my lord, they said that they have already paid the compensation to the PHE
When you file,
department.
when can you file it? As early as possible.
At the earliest.
When?
2 weeks.
My lord,
You miss
if I
out.
may submit, the issue with regard to which my friend has just submitted, that the union has released money to the state government, to the PHE department. On the last occasion, one of the occasions, I have made a submission that I'll take instruction whether this money has been with regard to the damage to the petitioner's case, my lord. Here we have received certain materials in which, my lord, it has been very clear that these are with regard to some other things, my lord, not with regard to damage of this education project, my lord. So we have those materials. If lordship permits, we can read. It will be more clearer, my lord, that way that this.
You will file another affidavit also.
My lord, we have already filed an affidavit with regard. There are two departments. Water.
Okay, you do one thing. Mr. R. Denmark, Leonard Counsel for number 2, submits that due to the affidavit file, in view of the affidavit filed by the state respondents, 3 to 11.
No, my lord, we have filed only in behalf of respondent number
3.
Respondent number 7, my lord, water resource.
In view of the affidavit file number 7, certain issues have cropped up which need further clarification for this court. We therefore praise that we be allowed to file additional affidavit. Stop the praise allowed. Next, on this submission, MSR Kolni has also submitted that on receipt of further information with regard to the disbursement of compensation, it is necessary that the state respondents also placed on record certain other facts. Next, in view of this development, respondents 1 and 2 and
Madam, I represent respondent number
3 to 11.
3 to 11.
Are permitted to file this affidavits within a period of 2 weeks from today. It's less than after.
Obliged, madam.
Item number 6.
This matter, my lord, we file our affidavit, and even the petitioner has also filed their rejoinder.
Already, I have filed, my lord.
What's the matter about Mr.
This is the headman, termination of the headman, my lord. Creation of the village, my lord.
Yes.
Yes. May I please, your lordship?
Yes, please. Start.
Initially, my lord, this Gambura was appointed of the Vularbita, consisting of 3 villages, Vularbita, Borshibanda and Goladegli, part 2, my lord. Thereafter, what happened, there is excess number of households, so he cannot manage. Mutually understanding the Gambura of the Vularbita and the petitioner, my lord, and he has given no objection for giving the village Borshibanda and Goladegli part 2 as a separate Gambura, my lord. So accordingly, my lord, they have appointed me as a Gambura of Borshibanda and Vularbita part 2, my lord, in Annexure 2, page number 22, my lord.
Annexure 2. Annexure 2?
Page number 22, my lord.
This is down 16.
Yes, my lord.
This is for life.
Yes, for appointment of the Gambura, my lord.
Yeah, please.
In person, this and that.
Manaf, the petitioner.
Yes, Abdul Munaf. That is.
Village.
Yes.
To the post of Gambura of Borshibanda
and
Goladegli part 2. Okay.
Village.
Right, what happened after that?
Thereafter, my lord, what happened? It is come to the knowledge of the petitioner that some of the vested interest, a few vested interest person, trying to bifurcate the villages, my lord.
Which village?
That is Goladegli part 2. I am the resident of the Goladegli part 2, my lord.
Okay.
Then what happened, my lord? Then the villagers, they have submitted a representation to the secretary, my lord. It is in page number 23, annexure 3, my lord.
Yes.
So they are requesting that such kind of complaint, if any file, it should be considered because majority of the villagers are in favor of the petitioner, my lord. So if it is submitted, it should be rejected.
Okay. So what happened after that?
After that, what happened, when I also came to know from reliable sources that somebody is making some complaint, my lord. So myself also submitted a representation in annexure 4, page number 24.
But out here written annexure 4. Now, but out here subject is unjustified claim of bifurcation of
Yes.
ownership of
Yes.
Banda.
Yes, my lord. So I come to know from the reliable sources, my lord. Then I have requested the secretary not to consider it without providing me an opportunity of a hearing, conducting the inquiry regarding this matter, my lord. Then they have passed an impugned order, my lord, in page number 25.
Yes.
That they have created a Gambura of village part 2 bifurcating the Borshibanda Gambura, my lord, on 24th April 2020.
So Borshibanda area includes this Gola Digli also.
Yes.
That correct, Mr. Day?
There's two villages, my lord.
No, wait, okay. But
Adjacent.
But before
Together.
the Gampura for Borshibanda and Gola
Yes.
Digli part 2.
Yes.
And he says the resident of Gola Digli part 2.
Yes.
And so now you bifurcated.
We bifurcated the
You've taken out
the village.
Then thereafter, my lord, in the page 26 annexure 6, my lord, they have passed an impugned order.
Yeah.
Dated 5th May 2024. Shall I read out, my lord? In pursuance of the notification dated as 24, the Executive Committee of Garhwal Autonomous District Council Tura is pleased to appoint Mohobul Sheikh, son of Abdul Jalil, as a Gambura of Gola Digli Part 2 village, bifurcating from the Borshimbanda Gambura for 6 months with effect from 1st May this one, my
What's
lord.
the stand?
Then, now my stand is that, my lord,
Stand.
as per the
Why they
rule-
bifurcated it?
Huh?
Why have they bifurcated it?
That is the complaint. I am coming to that point, my lord. I am coming to that point. Now, they have not given any opportunity of hearing, no inquiry, no notice was served upon to me, my lord.
No inquiry.
No inquiry, nothing, no notice was served upon me, my lord. Now, I am coming to the affidavit filed by the respondent from District Council Authority, my lord. In page number 10, my lord, in affidavit in opposition filed by the Garhwal District Council, my lord.
Yes.
Here, my lord, shall I read out, my lord? Proceeding for general meeting of the village Goladugli Part 2 for the selection of Gambura had been held today on 10th August 2023 at 11 a.m. under the chairmanship of Ekramul Kaji, son of late Abdul Kader Kaji, in the premises of the Mubarak Ali, my lord. In the meeting, it has been discussed thoroughly among the member and villagers present. In the meeting, a resident of Goladugli Part 2 village, Mr. Mahabul Sheikh, son of Abdul Jalil Sheikh, has been selected by raising hand of the majority member present there to make him as a Gambura of the aforesaid village, namely Goladugli Part 2. The meeting has been...
Where's the bifurcation order?
No, huh?
Where's the bifurcation order?
No, bifurcation order into annexure 4, my lord, in my...
No, annexure 4.
Annexure 5, my lord, sorry, my lord. Annexure 5.
Okay, because let's go with your appointment. You see, to the post of Gambura, Borshibanda and Goladugli Part 2. Now again bifurcating from... Now you're still calling it Goladugli Part 2, Mr. Day.
Yes, yes, my lord.
You haven't given a new name.
No, no, no.
So Goladugli Part 2, now Borshibanda is different?
Yes.
You've taken out this Goladugli Part 2 from Borshibanda?
Yes.
Is that the case?
Yes.
Okay, yes, continue.
Here, my lord, what happened? Villager has got no right to select the Gambura they can make a complaint to the district council regarding me, my lord, and the villagers, the signatories here, my lord, about 213 or 23, my lord. Out of that, signatories in the petition.
Who's Akramul Qazi? Who held the meeting, who chaired the meeting?
No, maybe the villagers of the Borshibanda, my lord.
Okay, then what happened?
Then out of these 223, my lord, 154 are from the outside, from the Vlarvita villages.
Yes. Then what happened?
Someone, yes.
Then you wrote complaints.
Yes. Thereafter, my lord, it has sent to the Garhwal District Council. After getting this complaint, so to say, complaint or selection of the things, this district council authority must have given me the show cause notice to reply on this point, my lord. But no show cause notice was served to me because Gaumbura is treated as a government servant. So Article 311 is applicable in this matter, my lord, as per the Assam land law, my lord. Section.
Okay, what happened after that? You wrote a complaint.
Yes.
That's page 31.
Yes, my lord.
This your
Not the complaint. I am when I came to know from reliable sources that then I have submitted it, not to entertain.
Page 31.
Yes, page 31, my lord.
Yes. Yes.
Then come to page number 32.
Yes.
The Alice inquiry, my lord. They are writing in the Garo. Then translate copy in the page number 33, my lord.
Yes. What inquiry is this?
And that is inquiry regarding this allegation. They have submitted the letter on 10 August 2023, my lord. So, before making any inquiry, my lord, that district council authority must issue notice to me as well as the villagers.
Right.
For conducting the inquiry, my lord. But they have not issued, and district council authority cannot show even a single notice as served to me, my lord. I read out this one, my lord. What kind of inquiry was conducted? Sir, with due respect written to the revenue officer by the one Mojadar, my lord, 3 Mojadars. With due respect and binding of the office order dated such and such, we 3 of us today on Tuesday dated 7/11/23 had done the spot inquiry, my lord. At the time of inquiry, many people has created chaotic drama and argument, but we resolved the situation and started inquiry. The supporter of Borshibanda Gambura has run away. So it is a very funny thing, my lord. They have run away from there. So therefore, we could not take the statement of President Gambura, but we could see that most of the people did not like Abdul Mannab because at the time of need, he always shows the attitude. It is true that the people of Borshibanda has run away, my lord. We therefore ask the people of the Galadil part to that they one stay under the Borshibanda Gambura or not. We had even asked whether they need a new Gambura or not. In reply to the question, they replied that they need a Gambura for the Galadigli part 2 place. So therefore, sir, we are requesting you to divide or to do partition or segregation the said area of Galadigli part 2, my lord. Here is, my lord, what happened, what kind of inquiry, my lord. They must issue the notice.
Right, no, only that because you showed
yes.
attitude.
Yes, that is the one-sided thing. Myself also, I do not know whether the inquiry was conducted or not.
Yes.
Thereafter, come to the page number 35, my lord.
Yes, what is this proceeding?
They are the note sheet from the order, note sheet of the district council, my lord.
What order is this 5324?
This council will know, my lord. Here they are writing both the parties are present on 7/12 Atho. File the directed to file retention by Next date fixed and author, my lord.
Then you see you not issued notice?
No notice has been issued.
Then who appeared on your behalf?
No, I have not appeared, my lord.
Then both parties present, both parties
Well,
submitted
they are writing the falsely, my lord.
Order fixed for
Yes.
order on so and so.
Yes. I have not
How
present.
can they generate this order sheet officially if there was no proceeding?
Yes, my lord.
It's all fabricated.
Yes, my lord. They have made it from their own site for helping the private respondent number 5.
So read this order. Order dated
Yes.
5th of March 2024.
Oh, yes, my lord.
What does it say?
Yes. Case record put up today. This case has come to this.
See, para, without opposite party, see Abdul Monaf, here the petitioner has also filed a statement objecting the creation of new Gomra area by bifurcating.
I have not submitted, my
It
lord.
was impossible to bifurcate one. He also claimed authority as point is answer. He claimed the both of them were friends. So, okay, read the order.
Yes, my lord.
Then how has it recorded officially that you were present and filed a statement?
They are making, my lord. On 19,
with you, Mr. Day?
Yes.
On 19, I went, my lord, and I have submitted the representation which I have already told you, my lord.
What is the statement did you file?
No,
okay,
no,
read this
that
order.
is-
Read this order.
Yes. The case record put up today, the case has come to this authority to one Siri Mobul Sheikh has filed an application for appointment of Gambura of village Goladigli Part 2 by bifurcating from the present Borshibanda village, my lord.
Yes.
So this private respondent
Okay,
filed an
just read the order,
application.
read the order.
Yes. The petitioner is the candidate to appoint for the post of appointment of Gambura of Goladigli village bifurcating present Gambura of the Borshibanda village. The petitioner stated that Goladigli Part 2 is one of the biggest and having huge number of population which is administered by Borshibanda Gambura, and as such it is very difficult to manage the day-to-day affairs of the village, and also the people of Goladigli Part 2 is facing serious difficulty and hardship to obtain any certificate or verification from the present Gambura of Borshibanda village. That is the mere allegation of this case.
Yes.
Therefore, the petitioner prayed that in the interest of the people of Goladigli Part 2, the new Gambura area may be created from the village of Borshibanda and appoint a new Gambura bifurcating village of Borshibanda, which will consist of 4 more villages, which are Baliadoba, Bindabari, Sarhadotpara and the Nodapoti. Opposite party Sri Abdul Munna.
They recorded your submission, yes. Yes.
Opposite party Sri Abdul Munna has also filed a written statement objecting the creation of new Gambura area Goladigli Part 2 by bifurcating the present Gambura of Borshibanda, my lord. But I have not filed. I don't yes. He stated that the Borshibanda village is not a revenue village, so it is impossible to bifurcate the Gambura sheet of 2 villages, namely Borshibanda and Goladigli Part 2. He also claimed that the authority has appointed another Gambura of Vlarbita, Borshibanda and Goladigli Part 2 by the name Sayat Hossain, White ordered such and such, which he claimed that both of them are friends and looking and solving all the problems collectively for the above said 3 villages. In view of their submission so made by both the parties and in the interest of the people of Borshibanda Goladigli Part 2, etc., this authority finds it fit and proper to create a new Gambura of village Goladigli Part 2 by bifurcating these villages from Borshibanda Gambura area and appoint a new Gambura Sri Mohbul Sheikh for a period of 6
So that you were heard, you filed a statement, you were heard and they examined it.
No.
And they had authority to say, okay, fine. The village is huge, so we'll bifurcate it. No personal allegations against you. Yes.
Here, my lord.
Now, what is the problem? What is wrong with the order then?
What here wrong is that one person filed an application. It cannot be entertained without serving notice to me or the villagers. Inquiry must be conducted as per the rule, my lord. Wishes of the villager will be taken into consideration and the Mawjada report.
Okay.
And
the
majority
inquiry is there. All your people ran away, they said.
Inquiry is there, my lord, but they have not served any notice.
Whether the people were there, you also ran away, he said.
Run away, that is their version, my lord. Whether run away or not, I do not know. Because I have now served any notice. And according to the rule, they must issue notice to me. And before conducting the inquiry.
Your suspension, is there a case of your suspension or any action being taken against you? You continue to be the Gampura of what's the other village?
Yes.
Yes.
And
you continue.
Yes.
Right. It's not a question. Your office been taken away.
Yes.
Only that they bifurcated and appointed.
Bifurcation because I am also a Gambura of Goladegli Part 2. That is taken away me. That means they are suspension removing from the authority from that village, my lord.
But your position as Gampura is still there, or Borshibanda?
A Borshibanda is there. I am also villager of this thing, but they are violating. They must issue the notice. They give me an opportunity of hearing. Nothing has been done.
Mr. Day.
My lord, can you come to the writ petition, para 6, my lord.
Yes.
Now, if my lord, if I can understand the case of the petitioner based on this, my lord, may kindly say that the Secretary of the Executive Committee, Garo Suranavar District Council, was pleased to issue an impugn notification dated so and so, creating Gaubura area of so and so by bifurcating the Borsa Banda area without the opinion of general public and without any notice and inquiry, and also without giving an opportunity of being heard before issuance of the impugn notification, my lord. First thing. The second part of his, my learned senior's case is on page 15, my lord, para 9.
Yes.
Now, my lord, the main ground to challenge the impugn order dated so-and-so, the petitioner was appointed as a Gaubura of so-and-so village after inquiring opinion of majority villagers, Mozada report, with due consent and no objection from the Gaubura of so-and-so village, giving opportunity of being heard and as per due process of law, whereas the same thing is denied to the petitioner. No inquiry was conducted by the authority, no opportunity was given to the petitioner being heard before the issuance of the impugn order, not taking into consideration the fact of so-and-so, my lord. Now, my lord, may kindly see, this is the allegation by which, my lord, they want to build up this case, my lord. Now, my learned senior has already read out my case also, my lord. If my lord may kindly come to my affidavit, para 7. Before, yes, para 7, my lord, page 4.
Yes.
Before I read out the entire paragraph, my lord may kindly consider page 5, the last portion, my lord.
Yes.
Thereafter, the entire matter was placed before the Deputy Chief Executive Member, IC Land and Revenue, and both the parties, that is the petitioner as well as the private respondent, were duly summoned. Summon was sent. The case of the petitioner is this: notice was not issued, my lord. This is on oath. We have filed an affidavit, my lord, that summon was issued. Now, my lord, may kindly again come back to para 7, my lord, that the statement made in paragraph 5, 6, and 7 of the writ petition are entirely concocted, false, misleading, and hence denied. The answering respondent back to state that owing to the large number of villages, population of so-and-so, and the public demand for which the said village, a public meeting was held on so-and-so date, my lord. In the said meeting, wherein hundreds of signatory villages has unanimously resolved to bifurcate the said village and to appoint respondent number 5 as their Gaubura. Now, my lord, may kindly see the complaint which was filed, not exactly complaint, it is a proceeding, that is on page 10, annexure 1, my lord.
Of your affidavit.
Of my affidavit, my lord.
No, that is read.
Yes. Now, my lord, may kindly consider the name of the people also who doesn't want him to be the Gaubura of that village, and they want bifurcation, my lord. The number of people who has signed against of him, my lord.
Yes.
Now, my lord, may kindly see page 33, my lord. This is a letter which has been written to the revenue officer by the Mozadar, my lord, after the spot inquiry was conducted. And this
What is this handwritten thing?
Which one, my lord? This is an office note, my lord. We have typed also, my lord. We will take through, my lord. to the Revenue Officer, Garoli Autonomous District Council, dated 16 November 2023, inquiry report in writing. With due respect and in abiding with the office noted dated so and so, by this date, my lord, and notice was issued to the petitioner also, my lord, had done the spot inquiry. At the time of inquiry, many people has created a so and so an argument, but we resolved the situation and start the inquiry. The supporter of so and so has run away. Now, my lord, the supporter of the petitioner has run away. So, therefore, we could not take the statement of the present Gaubra, but we could see that most of the people did not like so and so, Abdul Manaf, because at the time of need, he always show his attitude. It is true that the people of so and so has run away. Therefore, we have asked the people of Goldagili that they gonna stay under the so and so village or not. He had even asked
just
whether
stop there. So the fact remains that you issued summons.
Yes.
There was an inquiry.
Yes.
You filed a written statement.
Yes.
The matter was decided.
Yes.
So how are you trying
Now, my
to
lord-
say that you not heard the notice issued?
Now, just a minute. My lord, I will just answer to this, my lord. This is the Hazira, my lord, that he has filed. Now, he cannot say that this signature, we have copied this signature in the district council. This, my lord may kindly consider this.
Yes, before that I am, I know the fact.
You were
That when on 19 I went, my lord. No, listen.
But see, Mr.
When I going to
Your
submit.
case is that you were not heard at all. That everything done behind your back.
Yes.
And then the village is bifurcated.
Yes.
There was no inquiry as per procedure, and so that the whole decision is bad.
Yes.
But then if now from the facts itself it shows that you were there, you filed a written statement, you objected to the
No, that is,
area.
yes, that is there.
And the authorities who we cannot sit in appeal or decision of the authority if they feel that for the purposes of better village administration there, how do you how can the court interfere?
No.
If you were not heard,
yes.
if you are summarily,
Yes.
behind your back, we understand, yes.
No.
Maybe that decision needs to be revisited. But in the face of
No, here, my lord, it is appears that is they have managed it. Because on the 19 I went to the district council to file my representation when I came to know that some people are trying to bifurcate it. My lord, then there from the office you write one Hazira. Oh, this is not the court proceeding, why they can say there's revenue officer to write Hazira for filing this one.
So you file Hazira?
Then as they are telling we are the villagers.
He is the poorest person in this society.
Wait, let me finish. Let me finish.
My affidavit. My lord may kindly come to page 35, my lord. It's very unfortunate what he's saying, that we are manipulating his signature and everything.
Not
He's
signature.
saying,
Manipulating the matter, not signature.
my lord may kindly see, my
And the complainant, when 75% from the Vlarvita villages, 10 are minor, those who are reading in 7, 8. And even my brother, cousin brother and the nephew, their name also put in the complaint in the resolution, Alice resolution, by the
That shows
respondent
his own
number
cousin
5.
brother doesn't like him.
Because I am the Gaumbura for there, so I know it after
We can't
receiving.
decide this, Mr. Hazarika. Unless there's patently, it's some patently.
No, you-
Moreover,
my lord, I am
moreover, to bifurcate the village, my lord, it's a decision of the district council, EC, my lord. It is a policy-making decision of the district
No,
council.
we will not sit on decision. Only thing is the procedure that they have alleged that there's been violation of
That is
pre-natural justice.
total black and
Otherwise,
white.
how
No.
can we interfere?
We cannot show
No,
better
no.
than this, my lord, that
No.
he was hurt,
No.
written argument was filed by him.
No.
My lord may kindly tell you the handwriting of the Vahalatnama and this document, my lord.
Now,
My
here,
will be
my
able
lord,
to figure it out.
my lord, they have issued, they cannot show even a single notice is issued to me, my lord. They cannot show. And I have not received any notice or the communication from the district council, my lord. Because as per the provision, my lord, it must be contained. And even this inquiry, my lord, Alice is correct. They are supposed to issue the notice to the villagers and this thing. Not come to the particular person house and making all these things.
Okay, that means today is for admission hearing, only whether any interim orders are required.
Yes, yes.
At this stage, no interim orders. And the thing is that his terms expiring 11th. Let him finish on 11th November, and after that there be fresh elections.
No,
Fresh
that
inquiry.
is,
At that
that
point of
is,
time, if you can.
you see, my lord, even the villagers, 95% are in favor of me, my lord.
So why they run away?
Because no, only this now, that one I have not mentioned. Why they have filed? Because these 4-5%, they are taking the money of the Indira Awas Yojana household from the poor people, 10 to 15,000. So I objected for that. Then only they are making this one.
Then you file a criminal case.
That is not the case in this.
No, the things are, see,
No,
Mr.
I
Sarika,
am-
we're only going, this is a
No, I'm
only
going to the
by
record.
the materials that are present before us.
Yes, my
And
lord.
if it's shown that you appeared, your Hadira is there, you sign Abdul Manaf, you don't deny the signature.
No,
Now,
that-
even
that
there,
is-
even there, Hazira is there, handwritten, yours is typed.
No, that is, I have already admitted that when I gone, the revenue officer put Hajra
Deputy Chief
from,
Executive Member.
Yes.
Inside Land Revenue Branch.
Yes.
If that is the case,
No,
my lord,
that is-
where's the pleading?
Who's appearing for respondent?
No, here, my lord, that other thing. They have not issued any notice for inquiry and other thing.
Yes. You manipulated everything. Then?
My lord, I am little dubious, my lord. My learned senior has submitted all these things, all these notice, all these filing written WS before the district council is all manipulated, my lord. My humble submission, my lord, this instant matter may be dismissed with cost, my lord, because record is produced by Leonard Senior before this.
Now, my lord, I am.
This is my only submission.
Yes.
Yes, sir, take down as.
Then they can show any written statement I have submitted before the district
matters,
council. They cannot
fixed
show, my lord.
for admission hearing at the instance of the petitioner, citing urgency. Stop. Mr. H. Azreka, in his submission, has submitted that the matter concerns the bifurcation of the petitioner's village, of which he was a Gaunpura, namely Borshi Banda and Borshi Banda, BORSHI, and Gola Digili, GOLADIGLI, Part 2 village. Stop. The petitioner he submits was appointed as Gaunpura on
23rd March 2016, my lord.
Has been appointed as Gaunpura for this said area since 23rd March 2016. But however, the respondents by the impugned notification dated 24th April 2024 have bifurcated Borshi Banda Gaubra area and created a new Gaubra area of Gola Digli Part 2, and thereafter have appointed the respondent number 5 as its Gaubura. Stop. It is asserted by Mr. H. Reka that the entire proceedings were manipulated, as the writ petitioner was never heard nor given any notice in the entire process. He therefore submits he has taken the court to the various complaints and the inquiry, as also the order passed by the respondent number. Deputy CM, respondent number by the respondents of the council. Stop. He therefore submits that
he's not even made a party.
Yes, he further submits that due process having not followed and the bifurcation of the village being achieved purely on extraneous considerations, the same be interfered with, as well as the bifurcation of the village being achieved on extraneous considerations. The same as also the appointment of the respondent 5 is required to be interfered with by this court. Stop. Ms. SDN's reply has referred to his affidavit and has taken the court to the proceedings before the Deputy Chief Executive Member. Stop. It is submitted that it is not a fact that the petitioner was not present, inasmuch as from the records itself, that is from the Hazira and from the order, it clearly reveals that the petitioner had actively taken part and that only after being unsuccessful has come before this court with the grounds as stated. Stop. He further submits that as per due process, an inquiry had been conducted and on or for amicable reasons, as recorded, the respondent authority had taken the decision to bifurcate the village and to appoint a new Gaumbura for the same. Therefore submits that no interference is called for from this court. Stop. Mr. S.K. Hassan appearing for the respondent number 5. Yes, has endorsed submissions made by and support submissions made by Mr. S.D. and submits that you were bemused, you said, and submits that it's not a fact that the petitioner did not take part in the proceedings. Stop. Having heard and counsel for the parties, it is firstly seen that on the allegation that he was not heard, the materials as produced reveal otherwise. The Haziras, though not an affidavit, which are produced today, clearly show the signature of the writ petitioner, which is not denied by the council. Stop. Further, it is also noted that a copy of an inquiry has been annexed, though the same may not be exhaustive, has however portrayed the exact situation prevalent in the village on that day. Stop. The order, whether order, passed by the, that's annexed to your affidavit.
Yes, my lord. Order dated, my lord.
One second. The order dated 5/3/2024, whereby the decision was made for creation of a new Gaumbura village to create a new Gaumbura of village Goldigally Part 2 has also been examined, and from a bare perusal thereof, it is seen that the writ petitioner had taken part in the proceedings and also filed a statement objecting to the said creation of a new Gaumbura area. Stop. So this court, in consideration of the matter, is not sitting in appeal over the decision of the City Council, which has been made for administrative reasons, but is only to examine as to whether the rights of the petitioner had been violated in any manner, or whether he was not heard or allowed adequate opportunity. Stop. From the materials as placed and from submissions of the council, it appears that the writ petitioner had actively taken part in the proceedings and has come before this court being aggrieved with its said decision. Stop. It is to be noted that it is not a case where the writ petitioner has been removed from the office of Gaumbura, as he continues to be the Gaumbura of Bodibanda village, but only his grievance lies with the creation of the bifurcation of that village. Stop. For the reasons of on the given facts, circumstances of the case, there being on the given facts, sometimes no case made out of any interference by this court, and the petition accordingly stands dismissed.
Item number 7.
Yes, Your Lordship. Your Lordship, we received the affidavit filed by respondent number 2 yesterday, Your Lordship. Your Lordship, this matter...
Well, yesterday only?
No, I've already filed, my Lord.
When? Respondent number 2. Oh, number 2. Yes.
Respondent number 2.
You want to join the?
Your Lordship, may be posted, this matter may be
This is a
posted
revision,
for
my
hearing,
Lord.
Your Lordship.
Oh, revision, okay.
So will be posted for admission hearing, my lord.
What affidavit did you file? Just to bring on facts to the courts?
No, challenging the mental ability, my lord.
Oh, yes, okay. This matter for hearing on mental ability or the full matter?
Your Lordship, list the matter after 3 weeks. In the meantime, we'll file a rejoinder.
No. You already challenge, they can file objection to the your mentally.
If required, Your Lordship.
Mr. Dingdo, this is a matter be set for hearing. So he also prays that if necessary, we will have to file an objection to the application challenging the maintainability of the provision. Yes.
Item number 8.
After 3 weeks, Your Lordship.
Hello.
Interim may continue, Your Lordship.
Interim order is there?
Yes, Your Lordship.
Interim order may continue, yes. Yes. MS Panjong.
Lordship, here, respondent 5 is yet to file.
Lordship, I filed affidavit on behalf of respondent 1, 2, and 3, but 5 I may be given 3 days time. I'll be filing within 3 days time, Your Lordship. Everything is almost ready here.
Lordship, you have filed. 4 has filed.
Yes, Ibrahim raised for further 3 days time to file on behalf of number 5. This is the updates.
Hello, Your Lordship.
8 and 9,
8 and 9 connected, Your Lordship. 8 and 9 connected, Your Lordship.
10.
Lordship, we have yet to receive the affidavit from District Council, Lordship. I'm praying for a week's time.
Your Lordship, number of chances are given.
Yes?
We have forwarded the affidavit for signatures, Lordship. We are yet to receive it. I'm praying for a week's time.
It's going from where? By detour from where is it going?
Lordship, we have already made it and sent it for signatures. They're just yet to submit it, Lordship. Usually they submit in a bunch. So probably in a week's time, Lordship.
Interim orders there is 1 week's time was finally partially granted to respondents number 1 and 2.
1 and 2, Lordship.
So, file affidavit. Interim order continue.
Last chance. Last chance.
There's no meaning for them last time.
Because last time he took it, District Council has got a special status. And
special status not to file affidavit.
11.
Obliged, Lordship. Obliged.
Yes.
Item 11 for respondent 3 to 16, I have already filed my affidavit.
Respondent number 1, 2, 3 has not yet filed.
Where's MSM Hajong? Who's appearing?
There is on
Who's the council's power?
1 to 5. 1 to
1 and 2.
My friend Ms. Raji was there. I think she is MSN Raji, Lordship. On behalf of Mr. Dey.
Oh, they're from your same chamber only?
Yes,
Why will file affidavit?
She's here.
Yes? Why 2 weeks time? Last time we given enough time.
No, Your Lordship, we have some affidavit, Your Lordship, but we haven't received it.
1 week's further time for allowed to respond 1 and 2. Get it filed, else you'll pay cost. I think we start levying cost, like a taximeter, we'll make it run. You know, every day will be 100 rupees. So if you want adjournment, if you want adjournment again, after say last chance, then to 100 rupees per day or 500 rupees per day. So that way, then you know we can get some. Maybe give some to the bar association also, some here and there for charity.
12.
Why not?
Interim order is there, Malord. So it will
continue. Yes.
Hello, Malord.
Rejoin the file.
yes, my lord, we have documentation is complete from both the sides.
My lord, we have challenged the maintainability, the territorial jurisdiction of this honorable court in the writ. Because the cause of action, everything happened in Tripura, my lord. The NIT was issued from Tripura. They participated in the NIT, my lord. And later on, they abandoned the book, my lord.
You want the hearing today?
It can be done because documentation is complete. We have filed our
You want to have a hearing?
On maintainability first, my lord.
Yes, okay, fine. List the matters for admission hearing as the pleadings are complete on the question of maintainability. Yes. After? You take a date.
Up to 1 week, I can.
Take a date. Yes.
13.
Yes.
Lordship, as per the law's order, we have filed the miscase application, but it's not listed for implementation of respondent number 7, Lordship.
Who's number 7?
That is the first wife of the petitioner, Lordship.
Who's number 7?
The first wife, Lordship.
First wife.
First wife?
Yes, Lordship. But it has not been listed because we have filed yesterday, Lordship, miscase.
Let's come anyway. We'll take down miscase number 157, 2024 in WC number 143. Excuse me. Of 2024. This is an application for implement of One Srimati Porilla Marak, P-O-R-I-L-L-A Marak, respondent number 7 in the instant writ petition 143. Yes. You have any objections? Yes. As it appears that the Srimati, as it appears that Srimati Porilla Marak is the first wife of the petitioner.
Lordship.
Who's Josna Sangma? She's the employee.
He's the employer retired now, yes.
Huh?
He's the first wife of this of the petitioner. Yes.
She Josna Sangma?
Yes.
Is lady or?
Josna Sangma is the wife of the.
No, 1 second.
Is the husband of the. This.
1 second, 1 second. Okay, 1 second. Okay, yes. Of the petitioner who had filed the objection against the release of pension. As such, he being a necessary party, the writ in this case allowed, and Srimati Police is hereby implemented as respondent number
7, Lord.
7 in the connected writ petition. A paragraph in the main case, in view of the order passed in MC number so and so, registry to add Srimati Porilla Marak, no?
Porilla Marak,
as respondent number 7. Stop. Petitioner to take steps for issuance of notice within 3 days after this.
Authorized, Lordship.
As a pledge.
Item 14.
We are still awaiting instructions.
What instructions?
I have not received any instructions still.
Which department is this?
No, this is medical help. Kindly grant me 2 weeks time.
How where is the matter filed?
This is matter filed in, came up for motion on 11/6.
You already filed affidavit, but
Yes.
how can they file it so fast? You haven't got instructions.
My lord, I'm praying for 2
we'll make
weeks.
officers stand here with the file.
My lord, kindly grant me
If
2
you, no affidavit comes, we make them stand in from the record and dispose it of what is there. Ms. Kivaraji prays for and allowed for the week's time to obtain such file affidavit. Yes. Affidavit we have respondent number 5.
Yes.
It's already on board. Yes.
15.
Please, Lordship. Lordship, I have filed the affidavit of service report.
You filed it?
Yesterday.
2 and 3?
Yes, Lordship.
You have 2 and 3?
I'm for 4, Your Lordship.
What about 2 and 3? No appearance. Mr. Ilalu submits that an affidavit of service has been filed.
Yes.
Indicating service upon 2 and 3. The same is Barust, yes. Babu India, yes. However, no appearance been on their behalf today. What do you want today?
We'll wait, Your Honor. We'll wait for the respondent.
You're filing affidavit?
I'll be filing in the course of the day, Your Lordship.
Mr. G. Sinkaram, counsel, for respondent number 4 submitted affidavit file in the course of the day. MS Pradhan submits no affidavit before coming from these from respondent number 1 as their formal parties only. Just the matter after 2 weeks for the rejoinder and for appearance of respondents number
2 and 3.
2 and 3, yes.
Highly obliged.
16.
You've taken steps on respondent number 4 and 5 minutes.
You've taken steps?
Yes, madam. It come up after a week, madam. Service report is awaited.
Yes, officer indicates that service is not yet complete on respondent 3 and 4. We
4
wait.
and 5, madam.
3 and 4.
Madam, 3 and 4.
You want to make one more respondent? Yes. List after 2 weeks for service report. And you filing affidavit?
Or the grievance is mainly against the
17. It's for filing affidavit by the state respondents. It's for filing affidavit by the state respondents.
By state respondents.
17.
17.
Well, I'm looking for 4, 6 and 7. NHIDC. I'm praying for some more time.
I'm making some more sure
Mr. MSZ Inokani 4123 and Dr. Nbozika for 4667. Pray for not for a 2 weeks time file affidavit. Mr. S. Deb on behalf of 108 submit the new affidavit coming from the set respondent. This list after 2 weeks.
Allow the interim order may continue.
Interim orders, if any, shall continue till next day.
Item 18.
If Lordship takes up item number 19 first, 19, they have filed an affidavit, and this...
Today?
Yesterday or day before, I don't
Lordship,
know.
we filed yesterday, Lordship. There's been a slight technical hitch. We received the copy yesterday. The registry would not accept because it's not in the both side.
But then you correct the format.
So
Common substance, what does it say?
It says that they are withdrawing the order which they passed. It was a mistake, and they were lately communicated the court's order. That's why it happened. Now this matter can be disposed of with a direction to them to give us a hearing and dispose of the representation.
Give them a hearing.
Absolutely, gratefully, Lordship. Yes.
But the thing is that, see, whatever it is now, now in these kind of situations, are they at liberty to seek dealership from any other retail outlet, from any other company? Or they're bound by Indian Oil?
Yes. No, Lordship, they're not bound by it.
They're not bound
Or
by
they has a monopoly over the other
absolutely
oil
not.
companies?
No.
No. Suppose it's cancelled by Indian Oil, are they eligible to get dealership from any other?
Absolutely. Lordship, this item number 19 stems out for an independent advertisement.
It's not, not connected to...
18 is connected.
Lordship, what had happened in 18? 18 was withdrawn on the ground that the site will be changed, and once the site is changed, then the necessary, whatever the requirement is done between the All India Company and the Ashok Enterprise. Due process will be followed. The only issue involved there was, Lordship, the old land, the old relationship between All India and Ashok Enterprise was on a site A. The structural relationship was site A, and in a site A situation, the agreement has to be always been signed. In the old case also, the agreement was signed between the Government of India, the President and the Oil India.
The lease has to be by Oil India and the other person.
So you mean it's a company-owned pump?
Company pump. But here the lease is in my name.
What has happened in the item number 18? Issue is this: they entered into a lease with Government of Meghalaya. They should have entered into, and the moment you enter into a lease with Government of Meghalaya, then the site does not remain site A, it remains site B. So the issue is site A.
Site B means they are free to do whatever they want.
They are free to do whatever they feel like. They can enter into
an entire relationship that
absolutely it's civil.
That was existing earlier.
So the liberty given by the Honourable Court when the matter was withdrawn, that stands eclipsed by the new cause of action. So they can still work it out if they want to. Then they have to repeat the whole process, get back the site A status, and allow the All India to enter.
What is the difference site A and site B status?
No, they want us to sublease. I mean,
what is the difference site A? You get better
Lordship, site A is the land is leased out by...
No, I'm talking about, is the pump, site A is better pump and site B pump, or the same?
No. It's a relationship.
I mean, regarding the...
Terms of engagement. There's
no change.
Yes.
Then what's the problem? I thought that site A means you allowed
nothing.
Those facilities you get,
Lordship,
where you have all gas stations, other places.
Absolutely.
So Lordship, both these writ petitions can be disposed of. 19 by asking them to consider my representation, and they'll pass a reasoned order after hearing me. And 18, Lordship, whatever happens, we can work out on our own. We're not necessary, since the relationship goes. we are free to do.
But they have not filed affidavit in 18, right?
We allow us to file in 18 to file an affidavit.
18, so there'll be a
18,
closure.
18.
I want to be clear
19,
about
19 can be disposed of, Your Lordship, because
19 can but 18 let it be proper
They
closure.
have filed an affidavit. Have you
Lordship will
not
file an
filed?
affidavit on 18. 19, Your Lordship, in any case, they file a representation against the 19 July, where the court has granted.
Yes, Lordship.
Now the situation, Your
Let
Lordship,
them
we have
file a-
disposed of the representation.
Let them,
So it'll be on record, yes.
let them file an affidavit.
Yes, we take item 19 first. Yes,
The only thing, Your Lordship, is that we could not file in spite of the fact because of that.
Doesn't matter, dispose of, how does it matter?
See, if you,
Let us see.
Lordship can have it.
Dispose of.
Page 5, annexure 1.
just formatting still a lot of problems because average coming outside, this is a recurring problem now.
But Lordship, if Lordship wants the correct format, then Lordship kindly accommodate for a week. Maybe next week we can find the proper format.
Yes,
whatever, Lordship.
You don't need to trouble you. Let him be there, it's fine. 1 week. Yes, because let it be on record. Yes, because this is a cancellation, the revocation of cancellation is here on affidavit. And there's a stated violation of the court's order. That is why you should go on affidavit regarding the revocation.
Let both the matters be come. Let the both the matters.
What affidavit? When?
On the 10th?
Yes, Mr. K. Khan,
If it's
Learned
convenient
counsel
or
for the respondent, Command 2 today, submits that though the affidavit has been filed due to some formatting defect, the same will not accept but registry.
Lordship, yes.
He prays that he may be allowed 1 week's time to correct the same.
Lordship.
and
Lordship,
file
if it's
afresh.
posted on the 10th of
Yes,
10th of August,
this is the matter on 10th of
September, Lordship.
September, yes, for further orders. Just give it back and we list together. Number
18 and 19, both they'll file and we'll sort out both. I think both can be disposed of on that day.
Yes, in item number
18
item
and
number
19.
18, Mr. K. Khan pays allowed 1 week's time to file affidavit. Yes, on 10th September.
Hearing. Item 24.
Yes, one time.
Yes, Your Lordship. 2 weeks' time, Your Lordship.
My lord,
My lord, not here, he could not inform you.
Yes, my lord. My
But
lord,
we
in
maintain
the
a convention here that
my
the
lord.
council should be informed. That is why.
Yes, my lord. My lord, in the meantime, my lord, we are also.
You've given the money.
My lord, we are. I am trying to file one term, my lord, subject to the condonation of the applications that my lord will decide. But I'm trying to file one review applications, my lord, because it has. This has become something which is impossible for the managing committee to comply with the order, my lord. Because there's kindly appreciate, my lord, is a village consisting of about 36
Okay, you
households.
file it, we'll consider.
My lord, my lord.
After 2 weeks, yes.
My lord, obliged.
Sure.
$25.
May please, Lordship. This is the nature of a transfer petition. Lordship, what had happened, Lordship, is that the dispute relates to the All Saints Cathedral.
All Saints Cathedral?
The All Saints Cathedral is situated here in IGP Point, Lordship. The structure of the church is that the church is under the Church of Northeast India, headquartered in Delhi. Under the
But I thought it's Church of Northeast India.
Lordship, yes.
Or Church of North India.
Church of North India, CNI, Lordship. Under the CNI, there are various dioceses who head particular number of churches in a territorial division. And in Shillong, we have, Lordship, the Diocese of Northeast India, DNEI. Now, under the DNEI, Lordship, there are various churches, including the All Saints Cathedral here in IGP. And the All Saints Cathedral, Lordship, is headed by the Bishop of the DNEI. But at the local level, there is a committee, Lordship, which is called a pastorate committee. Now, the pastorate committee is headed by a presbyter in charge, who is the petitioner here, Lordship.
Presbyterian Church?
Presbyter in charge.
Oh,
I see, in charge. In charge.
What is it called?
Presbyter.
Presbyter.
Yes. P-R-E-S-B-Y-T-E-R.
Never heard of it before.
B-Y-T-E-R.
P-R-E-S?
B-Y-T-E-R.
presbyter.
Okay, presbyter.
In charge, Lordship.
Means? What presbyter means?
He is the head of the committee, the pastorate committee, head of the church.
Head of the church committee.
Head of the
Which
church.
the bishop was the head?
Bishop is the head of the diocese. He is the head of the committee.
Particular church.
Lordship. Now, if there were some disputes between this presbyter in charge and the other members of the committee, and certain resolutions were passed against the petitioner as well as the bishop and so on and so forth. Assailing those resolutions, Lordship, a title suit was filed by the plaintiff. Now, if Lordship is pleased to come to page 253 of the petition, Lordship. Page 253, Lordship.
He is a presbyter.
Lordship.
He heads the committee.
Lordship, yes.
And what is Shillong? Then if he heads this Shillong Pastorate Committee, why is he filing a case against Shillong Pastorate
Yes,
Committee?
if I may just explain, Lordship may kindly see this is the order passed in the title suit at the stage of motion. Lordship will kindly see, I may just read out very quickly. 24th November 2023, CR put up today. Learned counsel for the petitioner is present.
A little loudly, I can't hear you.
Yes, learned counsel for the petitioner is present. He submits that he is not pressing for any ex parte relief in the matter with the exception that the letter dated so and so bearing reference number so and so should not be put into operation pending the appearance of the opposite parties. The impugned letter contains details with regard to the resolution made in the annual general meeting of Shillong Pastorate, Diocese of North East India, Church of North India, held on 23rd September 2023, communicating to the plaintiff, Reverend so-and-so, the decisions of the AGM. Learned counsel for the petitioner has expressed anxiety that the 3 points mentioned in the letter will be put into effect shortly. These 3 points pertain to 1. Endorsement by the AGM of the Special General Meeting's resolution to not recognize the petitioner as the presbyter in charge of Shillong Pastorate and to discontinue the petitioner's ministry in the pastorate. 2. That the Shillong Pastorate will not contribute the salary of the petitioner with effect from 1st October 23. And 3. That the petitioner is to vacate the Shillong Pastorate's parsonage within 2 months from 30th September 2023. Without going into unnecessary detail, some important facts may be noted. The petitioner is the presbyter in charge and the ex officio president of the Shillong Pastorate Committee. The Shillong Pastorate Committee is a body subordinate to the diocese, which is in turn subordinate to the synod. From the materials on record, it appears that a dispute has erupted between some portions of the Shillong Pastorate Committee, the petitioner and others at the diocese level. The petitioner, amongst other things, has argued that both the SGM and thereafter the AGM were not properly called for, and the 3 points referred to in the impugned letter are beyond the scope of the powers of opposite parties number 1 and 2 as per the Constitution of Church of North India. At this early stage, only limited relief is granted on an ex parte basis, such that the petitioner is not deprived of his shelter and not restrained from discharging his duties, which are continuous and continuing. Therefore, till the next date of hearing, number 1, petitioner is not to be evicted from the premises occupied by him by OP number 1 and 2 or any person acting through or under them except by due process of law. And 2, opposite parties number 1 and 2 are restrained from interfering with the petitioner's discharge of his duties as presbyter in charge, except in the manner as permitted by the Constitution. With regard to the third point pertaining to the contribution to the salary, no ex parte interim relief is deemed to be required at this stage, inasmuch as opposite number part 1 and 2 actions are to be circumscribed by the terms of the Constitution that are operating under, and any further orders in this regard will necessitate both sides being heard. Now, this suit was filed, Lordship, and this order was passed on 24th November 2023 by the Learned Assistant to Deputy Commissioner Judicial. Now, the opposite party's defendants, Lordship, they entered appearance and they filed a objection on the ground that the cause of action arose in the normal area because the church is situated in IGP. And in that view of the matter, Lordship, we have filed this instant transfer petition to transfer the matter to the court of the Munsif, Lordship, to be tried from the same point where it was.
Who's the Munsif? The same presiding officer?
Same presiding officer. And then
I'm appearing for opposite party number 1, the pastorate committee. No, my lord, in this case, I entered appearance, my lord, on 5th December 2023.
In the
before the court of the assistant.
Court, yes.
First thing we have noticed, my lord, this was filed before a court which do not have the jurisdiction.
Yes.
We filed an application, my lord, questioning the jurisdiction to entertain. Now, they on 5/12, my lord, is very important. They also participated in that proceeding, my lord. Proceeding, my lord, the issue raised was the court is not competent to take up the matter. Now, they participated and they sought 1 day's time. Court granted ultimately 1 day's time to file show cause on the issue regarding maintainability, my lord. And the matter was posted on 7/12/2023. And the ex parte interim injunction was extended only up to, my lord, 7/12/23. Now, my lord, in fact, we are ready for the hearing on this issue. Neither a show cause was filed, my lord. In the late evening, my lord, I was personally there waiting for it. One of the colleague from his chamber, my lord, she came with a order from this honorable court. Now, these honorable court, it seems they moved an unlisted motion seeking, my lord, transfer under 24(5). And this honorable court, my lord, while issuing notice, directed that status quo will be maintained. Lordship will note, with regard to the proceedings, status quo will be maintained by the parties with regard to the proceedings pending before the trial court. So, in this situation, my lord, the honorable trial court also, my lord, kept the matter, my lord, did not proceed further, nor extended the injunction order. Injunction order was also not extended. Now, thereafter we entered appearance and all, my lord, matter has been pending. Now, in the meantime, many things happened, my lord. The pastorate committee, my lord, the election was due. Fresh election was held. New presbytery came in place. Now, they have filed a fresh suit. Before the assistant to the district judge. Now, again, my lord. Now, my lord, this matter is pending and we are filing, we have entered appearance, we are filing our returns.
Why do you file again before the same court?
No, that is
the assistant to district.
With regard to a new certain something
fresh
different.
Assistant to district.
Completely
different. Not,
No, my lord. Assistant to district judge. Now, my lord, we have entered, we are filing our written statement. Now, my lord, here your lordship will appreciate one thing, my lord. Admittedly, now they also admit court do not have the jurisdiction. Now they are seeking, after participating in the issue raised, my lord, they were supposed to file the matter is to be heard. Instead of this, my lord, they have came before this honorable court. Now, my lord, 24(5), my lord, is very clear, my lord. This is, nobody can as a matter of right seek transfer, my lord, because there is other remedies, your lordship. This is a matter of pure discretion. There are other remedies, my lord, if they are admitting, my lord, the court do not have the jurisdiction.
No, the point jurisdiction will be decided by the court.
Exactly, my lord. My lord, why it should be
sought for transfer.
Why they? Because the proceeding they have participated. If they had not participated in an earlier stage, because this will lead to, suppose your lordship, transfer the matter. Now I have not filed my written statement. My written statement is required to be filed, my lord, within 90 days. Now what will happen to that? If it is only transferred. So what is required, my lord, they can contest this issue, my lord, before the assistant to deputy commissioner.
No, but are you still interested in this suit?
Yes, lordship. Because the new suit has nothing to do with the suit which
No, my lord, we have raised. They have sought, lordship will see, here they have sought a declaration, my lord, that he is the presbyterian in charge. Now in the new suit also
now
this...
there were no orders prohibiting the fresh elections or the...
No, nothing.
No such orders, yes.
And that election was held in March. A new committee has taken over on 31st.
24.
24. And the new committee has taken over on, my lord.
Now he's out.
He is out long time before, my lord.
Lordship, what my learned senior
are you out or in?
I am very much in. Why? Because the presbyter in charge...
How can he be in if they have fresh
If I may
elections? There's no orders
if I may
prohibiting
just
that.
explain, lordship, how the committee, which my learned senior is representing, is for a period of 3 years to be appointed by way of election. The presbyter in charge, who is the petitioner, he is the ex officio president of that particular committee, but his powers and position as the presbyter in charge is appointed for lifetime by the diocese, nothing to do with the election, lordship. So he remains the, and the diocese is also there to clarify the issue.
Pastorate.
And diocese is very much in favor of the petitioner, lordship.
Pastorate, my lord, which basically comprise of the congregation, the worshippers. Now, my lord, they in a general meeting passed a resolution, my lord, recognizing the president because of his conduct. Lordship.
If you go by what's come on record, right? Lordship. Now by the very fact they filed this revision application, it's admission that the court has no jurisdiction.
They are admitting. No,
So then,
they will have to go
then
and
the thing is that then the only thing is that the
return of the
the return of plaint.
Lordship, kindly see the order passed
Now,
by
see,
this
the thing is that now if you already contested that matter there on jurisdiction, and if you file application 711, yes. So if
no, they filed it under section 4 or that application.
Yeah,
is there.
that's
I
the
filed
point.
on 512.
Yeah, that's besides the point. What this court is saying that if you already agree that the court is on jurisdiction, right? Then all what remains is that now you have to take the plaint back and institute it in the.
No, kindly see the Lordship. Kindly see the order passed by
How
this
do you
honorable
expect
court.
this court to transfer now if you already contesting the matter on jurisdiction?
No, kindly see the order of 7th December passed in this matter.
Where's order 7 December? By this court?
Yes, Lordship.
Because that time you're not aware about this thing, you had concealed it.
No,
You have to
everything is
transfer.
here. Lordship, kindly see the order of 7th of December. If I may read, Lordship.
Yes.
Heard so-and-so, learned counsel for the petitioner who has submitted that this petition is filed before this court seeking exercise of powers of this court under provisions of 1B of so-and-so, rules 1937, analogous to section 24 of CPC. Submission of the learned counsel is that the title suit was preferred before the court of the learned assistant to deputy commissioner at Shillong, who has taken cognizance of the same in TS number so-and-so. The trial court on an application filed by the petitioner herein under Order 39, Rule 1 and 2 CPC has passed an order dated 24/11/2023 in Miss Case number so-and-so, pending before the learned court of the learned assistant to deputy commissioner at Shillong, inter alia restraining the opposite party respondents herein to interfere with the petitioner's function as presbyter in charge of the Shillong pastorate. Learned counsel has further submitted that the respondents herein has also preferred an application under section 21 of CPC objecting to the jurisdiction of the trial court to take up the matter between the parties, such application being registered as Miss Case number so-and-so.
Okay.
And so everything was disclosed.
Okay,
Now,
then.
under this circumstance, petitioner is impressed upon this court in the event an order is passed in ex parte as far as Miss Case number so-and-so is concerned, petitioner will be deprived primarily of the advantage of the injunction order already passed. In such eventuality, the petitioner has approached this court with an instant petition with the prayer that the title suit may be transferred to the court of competent jurisdiction. The learned counsel further prays that notice may be issued to the respondents. In the meantime, an order of status quo may be passed to restrain the parties of the trial court for that matter from disturbing the present position of the respective parties. On consideration of the...
Yes.
No, Lordship, will you please see the other part. What order actually court has passed? Court has not granted that. Court is the status quo with regard to the proceedings between the parties before the trial court will be maintained. Then the suit could not proceed further. And in these circumstances, my lord, trial court also has not extended the injunction order. Cannot. Because that is important, your lordship, the last paragraph.
Now
The order is very clear and very categorical.
When the order was passed, not to disturb the present position, the injunction was still in
wait,
operation.
Wait a second.
Yes.
When the order was passed by this honorable court, not to disturb the present position in the suit, the injunction order was very much in
No,
operation.
no, my lord, that order has never been passed, my lord. If you can just
We'll not go there, Mr. Singh.
No, no.
So,
What
this
order,
is
your
what
lordship?
you see.
No.
The only thing the court is going to do is iron out the procedural difficulties
At
that you
this
have.
stage, if I may submit, Lordship,
Yes.
the suit may be transferred to the Munsif, Lordship. We have made the prayer. And the injunction will be decided on merit, Lordship.
No, Lordship, my prayer is, my lord, I
don't
have filed
think
an, what will
anyone will
happen?
be prejudiced
What will
by
happen to my
that,
applications?
Lordship.
I have filed an application.
That becomes infructuous.
No. What? How lordship will negotiate with the facts, my lord? Negotiate with the facts, my lord. I get maximum, my lord, 90 days time to file.
No, that
In
the
view
court,
of the status quo, Lordship, the date will be...
that is ample provision, ample.
My humble submission, your lordship, since they have participated, your lordships.
No, it's on hyper technicality. The thing is that let the suit be transferred, and you let the injunction matter be heard.
Lordship.
Within 1 week.
Lordship, yes.
My lord.
In fact, diocese is in favor of the petition.
Lordship, it's not.
We are not concerned about that. Who's in favor of whom? Who's in disfavor of whom?
My lord, again, I am saying, your lordship, sorry, my lord, I could not bring a decision, my lord.
You bring decision, we'll hear you.
Slightly handicapped, my lord.
You
No,
make
what?
decisions. Otherwise,
No, it very categorically says.
It's just that. See, it's a admission.
Lordship.
Of the fact that the court where the suit instituted is not a competent court.
Lordship.
Right.
Lordship.
Your application under section 20 whatever before that court is on the same issue. That lacks jurisdiction. So in view of that, then this very fact that they file it here, that means admission of your applicant succeeds.
Lordship.
Has a jurisdiction. But in that view, they've already come and filed for transfer and have not concealed the fact for this court that you have filed an application. Only thing is very smart advocacy on their part. How to preempt, the orders being, nullified. That's the
No,
only
but
thing.
that order, my lord.
So you bring authorities, we'll hear you on Tuesday. Yes, I'm close to hearing Mr. Sen praising without presence of authorities. Yes, just on Tuesday. 20?
7.
As part heard.
Obliged.
You are appearing for whom?
Opposite party number 2.
Who are you?
The secretary of the Shillong District.
And Mr. Jindal?
Number 3. Number 3, diocese.
Item 29.
Obliged.
Interesting point, but that's the thing. There's no purpose we serve in hearing that matter then. Yes, Mr. Nongpa. He's left. Lip Shanjan. He's there.
Yes, sir.
Yes, Mr. Nongpa. Who's number 6? Ready the matter? Ready?
They are all ready. It's for the petitioner to make out a case.
Yes, Mr. Nongpa. Yes.
May it please your Lordship. Lordship, these two villages in question have been in dispute since many years back regarding the boundaries.
Nonghali and Menriang.
Nonghali and Menriang, Lordship. And then what happened? Sometime in the year 1992, it has been settled. But then again, the respondent number 5, that is from Menriang side, they have demanded more and more land from the CM, that is the respondent number 6, Lordship, Proforma respondent number 6. And then, Lordship, that the respondent number 6, the Proforma respondent number 6, the CM of Himahirim, has directed his background to cause a local inspection. And Lordship,
now one thing, Mr. Nongpa, you said that the boundaries were settled since 91.
It was Lordship, since.
And the boundaries were determined since 1991.
Lordship, after that, there was a meeting on 1991-92, but then again, either side was not agreeing with the arrangement. So again, Lordship.
No, see, in your synopsis, I'm just going back. You said that held on 14/91, discuss and settle a boundary dispute between two villages, and a meeting was successful. To the extent a boundary was settled and agreed upon by head of Menriang and Nonghali. Who's appearing for Menriang?
I'm appealing.
There's a fact. You agreed to the boundary in 1991.
No, all these orders are all set aside. They were all set aside. They were challenged, set aside.
Okay.
Now it's set.
Let them continue.
Lordship, ultimately on the 9/12/2015, Lordship, the
9/12.
9/12/2015, Lordship. Last time, in fact, I was. That's in page 51, Lordship. This is the judgment hukum dated 9/12/2015, which was passed by the respondent, Proforma respondent number 6, Lordship, the CM of Himahirim. Lordship, may I read, Lordship? This is very important order, Lordship.
There's the translated copy at page
51, Lordship.
It's been translated correctly, no?
Yes, Lordship. Last time, I read the wrong copy. Otherwise,
read the wrong copy?
I read the wrong copy last time. Otherwise, there's no mistake in paging.
Yes.
Judgment hukum dated 9 December 2015. This issue between Nonghali and Menriang villages started since the year 1991, when both villages were under the administration of one headman Sardar, that is the headman or Sardar of Nonghali. And due to the dispute and misunderstanding among the elders and the residents of the two villages, which has led to the demand of the residents of Minriang to have a separate administration in the village. The residents of Nohali insist on being together, that due to the fact that the two villages cannot be together under the same administration. The matter has gone to the Executive Committee, Khasi Hills Autonomous District Council, in which the KHDC Wide Order dated 28/04/2000, it has directed the CM and Darbar to recognize Minriang as another village. Therefore, there has been a demand from the village Minriang to get a clear boundary that would separate Minriang from Nohali village. Within the last 15 years, there has been an unfortunate incident in which the elders of the residents of Minriang have burnt the charcoal prepared by the residents of Nohali. In this regard, the then Sardar of Nohali, Liet Mawel Khasati, has lodged a complaint to this Darbar Wide complaint Dorcas dated 6/3/2001 against the Sardar, Henman and the residents of Minriang village. That after the Darbar has taken up the issue, it has passed the order Hukum dated 10/05/2001 by ordering the residents of Minriang to pay rupees 1,58,000 to the residents of Nohali as compensation. The residents of Minriang have not paid the said amount up till date. Besides the said incident, there has been many disputes between the residents of two villages to the effect that they destroy the corruption of each other. The issue has reached up to the government as per law. That this year, 2015, the Sardar of Minriang, S. Rangai, and the Secretary L. Nongrum has submitted a petition dated 20/04/2015 requesting the Darbar to settle the high-handedness of the Nohali residents towards the cultivators of Minriang village as per the report of the cultivators to the headman, Sardar, since the matter could not be settled among themselves. The CM of Hima Khairim instructed the Ministry of Right Nongkrem, Ministry M. Warba, Ministry H. Melimpra, Ministry Group, and others to organize a meeting with the residents of both the respective villages. In this regard, the report from those ministries, in short, are as follows: that on the 25/05/2015, the ministries have gone to Minriang village and explained to them about the mistakes in not paying rupees 1,58,000 to the residents of Nohali as per the order of the Darbar of the CM and the FIR filed against the residents of Nohali. The headman, Sardar of Minriang, together with those present, has asked for pardon for their misdeed and assured that they will abide by the directions of the ministry and the Darbar of UCM. The said decision has been supported by the persons present in the meeting by standing and raised their hands. The letter on the 28/5/2015, the ministry have gone to Nohali village and convened a meeting with the residents of village. That since the Sardar headman was not in the village, the secretary welcomed the ministry and requested them to chair the meeting. The ministry Warba has shown the letter from the Sardar Minriang and informed that the residents of Minriang are ready to forgive and settle any dispute and to pay the residents of Nohali for the charcoal and withdraw all the cases and FIR. The other ministry supported the statements of Ministry Warba. The elders of Nohali village have also expressed their willingness to forgive each other and even suggested that the residents of Minriang should come to Nohali village to discuss the matter at hand. The ministry has stated that the dispute between the two villages is due to the fact that there is no proper boundaries, and as such, the cultivators are encroaching into one another's land for cultivation. That since the residents of Nohali are bigger in population, they therefore tend to cultivate near the Minriang village. The ministry have suggested that there should be a proper boundary between Nohali and Minriang. However, the land of Nohali should be bigger than that of Minriang. They even annexed the copy of the sketch map prepared with regard to the suggestion regarding the boundaries. After receiving the report from the ministry, the CM, the chief, have summoned both the Sardars, headmen along with their executive members and with elders to be present at Smith on the 17/06/2015 to further discuss the matter /issue. That on 17/06/2015, in the presence of all the resolution in short are as follows: the CM has welcomed all in the presence of ministry. They have explained that there should be an understanding and to forgive one another. The residents of both the villages of Nohali and Menriang have expressed that they are looking for ways and means for peace and harmony. Therefore, it has been resolved that the residents of Menriang would go to Nohali and tender their apology for their mistakes and they further suggest in order to maintain peace and harmony. Therefore, the residents of Menriang, by letter dated 25/06/2015, informed the CM and the Ministry as follows: that they have.
Okay, Mr. Nokma, sorry to cut you short. Now, so what happened was that this dispute could not be resolved, that Charcoal River. Then they wanted to resolve the matter. Then finally, the CM decided that this is the boundary.
Yes,
correct.
correct.
As given in page 56 and 57. Then what happened after that?
After the Lordship, it has been regarding this. After this order in Lordship, there was peace between the residents of both the villages. They have to some extent settled, and then there was peace for quite some time, for a few years. But again, the respondent 5, that is the headman of Menriang, have approached the executive committee, KHDC, to give them more land.
Yes.
In which Lordship has in turn, the KHDC has directed the professional respondent, the CM of Herim, to give more land as per the wish of the
Menriang village.
That was done behind the back of the Nohali villages. And then Lordship, after that, that impinge order has been passed.
There's the order dated
impinge order is
by the CEM 24/10/2016.
Impinge order Lordship is in page
60.
88, Lordship. Page 88.
88.
88. So we are aggrieved by this order, Lordship, because why we are aggrieved, Lordship? Because by Annex 9.
Yes.
This is Lordship, by this order, Lordship, it has given room for the residents of Menriang to go to the other side where the Nohali residents are cultivating, Lordship.
So that means that in 2021, as per this letter, as per this order, that the boundaries were redrawn by Himakerim. They were redrawn. And if the company has referred this matter one man tribunal so and so, which so and so address has addressed is not a boundary dispute, it's a dissatisfaction, rebamlang, so and so forth. Then the executive committee had referred the matter to the CM Himakerim. This last paragraph of page 89, dated 12/10. The CM has informed the committee the decision so has been accepted and the boundaries have been once again demarcated. The committee by orders approved boundaries such as Himakerim by letter dated 12/10/21 and by order 20. The CM has confirmed one. So this you agree with this one? Do you understand?
Lordship,
now only one thing, when the boundaries were redrawn, were you heard or were you taken to confidence?
No, Lordship. We were not taken.
That's one of the 6 unilaterally went and redrew the boundary as per the directions of the executive committee. What happened?
There was a hearing, Lordship, in the KHDC.
Yes.
But then again, it was decided. It was decided in favor of Menriang village, Lordship, because they have not taken into consideration this previous order in 2015. So what I would like to submit, Lordship, that is the order dated 9/12/2015. That is the correct boundaries that should be upheld, Lordship, by this.
The earlier one given by the CEO of Kairim.
Lordship,
when
yes.
he could not decide that east-west boundary as given in that order he led earlier, that 9/12/2015, correct? Page 51. So your stand is that it should not be revisited anymore. But they had gone to the committee against
Yes.
that 9/12/2015. So the order is gone. So your prayer is that it should be reverted back to old.
Yes, Lordship, to that order 9/12/2015, Lordship. Because, Lordship, It's like this, Lordship. Has been always dispute, either from this side or the side they are claiming. And then, as a matter of fact, the parent village is Nohali, which is much bigger in size and in population. And this Midrang's on the other side. And they tend to come towards the side of
No, I
Nohali,
understand.
especially by this impinge order. They are giving more land to Midrang village, Lordships. Lordship, so my humble submission is, I'm afraid that dispute will come back after even, I'm not, because so many cases are there. Even title suit is still pending, Lordship. Title suit, we
How
feel.
do you settle this matter?
Lordship,
The thing is that, see, it's not a question, it's not a boundary dispute, this matter. This is simply respondent number. What is Minriang villages? Respondent number?
5.
The respondent 5 is not satisfied with the demarcation, that's all. That is why they went to district council again. It was upheld once. Then again they came to this court. Then to reconsider. Then again the executive committee gave direction to the respondent number 6 to demarcate the boundaries. And
Yes,
he has
Lordship.
done it, which you're not satisfied now.
Even,
so that's the thing. So what can this court do at this stage?
Lordship, even the respondent number 6, the CM of Maclean.
Because see one thing, Mr. Nongkolo, that process has been adopted, wherever it is, there has been an adjudication. You have been heard also. So what is this court to do at this stage, except that you have to, it's on evidence whether how much land you occupy.
My humble prayer is that, Lordship, if an attempt is made once and for all, again by all concerned, Lordship, by the respondents in the presence, by taking the confidence of both parties, then Lordship maybe.
Well, this matter won't end. Suppose order comes from this court, even say what will happen? That on the ground situation remains the same.
Lordship, that's why, Lordship, my humble
It's not
prayer.
a question of denial of any rights. In fact, it's just a question of you're a bigger village. You see, you deserve larger land. Of course, they're saying that demarcation that was done in 2015 is too small for them to cultivate. So although they were there in the meeting, although they had come and given apology, they said that now it's too small, so that's why they're dissatisfied with the amount. It's not a boundary dispute. It's not a question that our boundary was here before. No, it's a question of just like, we want more, and they've given more by it's one number 6. Now you agree. That's all.
See, Lordship,
what can the court do?
This honorable court can do one thing, Lordship.
Call them here.
That is directing all the parties and all concerned to once again make an attempt to demarcate once for all, so that with the confidence of both parties, so that peace may come back, and then that is the only way out, Lordship. Otherwise, I am afraid there may not be.
What's the population, Nonghali? What's the population in Mandaya? You come back with that and see what we'll do.
But it's much. This is parent knowledge.
This happens everywhere when other village bifurcate another village.
So
you come back. Yes, we understand your mind, and the courts. We cannot pass any orders, to put anything on the ground. We cannot do that because it's not a question of demarcation. It's a question of tribunal. It's a question of determining, of sending some inquiry. Say yes, what is it from before? It's like that from that tree to that tree. It's a question of just dissatisfaction. On the dissatisfaction, their dissatisfaction, everybody asked the respondent number 6, he gave them some more land. Now you are dissatisfied. What's the present situation on the ground? Is there any conflict on the ground right now?
Yeah,
or
they are jumping from one
cultivating
end.
within your respective areas.
They are jumping each other.
Time and again they are.
Actually,
From
the
either
people
side.
of that area also are cultivating here. The people from that Miriam building also. That is a system everywhere in Rikasi.
So, Lordship, if Lordship is pleased to direct all.
You just come back, just give the census. You'll have the census of the village. We'll see. Yes, list the matter for further hearing after 2 weeks. Yes. Otherwise, we'll have to pass some orders which we've sent for big village mediation.
Item 30.
Yes.
Obliged, Lordship.
Yes.
Lordship.
Yes.
Lordship, I'm appealing for the state respondents in this matter.
Yes.
If your Lordship kindly peruses order dated 2/7/2024.
Order dated?
2/7, 2nd July.
Yes.
Lordship, I was directed to come up with specific instructions
Yes,
of
where's the
any
instructions?
officer memorandum. Lordship, the instructions are there. There are two notifications, Lordship. The first notification was issued on 25th of January 2007.
Give him a copy. You receive copy? Yes.
Lordship, the first notification was 25th January 2007. If I may read, Lordship, on the subject cited above, I am to state that for the improvement of the quality of education, it is desired to implement the NCTE standing guidelines, which are mandatory, which prescribe that all the teachers at secondary level are to be graduate with BEd. As such, you are hereby informed to ensure all vacancies in deficit secondary schools should be filled up by BEd degree holder, failing which no approval should be accorded from this office or your office. This shall come into force with immediate effect. Further, the appointment against BEd deputation vacancies should also be made with BEd candidates.
So you have to have BEd admin.
Lordship, the petitioner does not have the BEd.
Yes.
Now,
So what do you do,
my Lord, if you may take your
Islam?
Lordship to the notification. My Lord, notification dated 19 July is very specific, my Lord, on the petitioner's
It does say
case.
seniors.
It is for a newly appointment. New appointment.
What about 2007? When were you appointed?
I am appointed as 27/10/1992. I have joined on 1/11/1992. Your Lordship, page 17.
No, but the thing is that if the requirement is there,
but
should be a duly qualified. At that time, what was the education qualification required?
Only graduation.
Graduation.
My Lord, if I may submit on this, my learned senior had come up with the rules before this honorable court, which had already been repealed, and there it was clearly mentioned that for being appointed as headmistress, the qualification was 7 years of service. Subsequently, I came up with instructions and I placed the currently prevailing rules in aided government schools, where it is provided that it is 7 years of service along with BEd degree. Now, when the NCT norms were introduced, thereafter all these serving people were given an opportunity to
qualify.
get the qualification, which has not been done by the petitioner in this case. There was another case to which the petitioner was referring, that a non-BEd candidate was appointed as assistant headmaster. To that also, Lordship, we had filed a specific affidavit stating that he was in his 4th semester of BEd. He was undergoing BEd, which is at Annexure 3 of my affidavit in opposition. And since he was in the final semester of his BEd, my Lord, that was the only reason why approval was granted to him for appointment.
Yes, Mr. Islam, what to do?
Affidavit also misleading this court, Your Lordship, because I am submitting that. Yes, that misleading statement, Your Lordship, by the respondents. Your Lordship, paragraph 4 of this affidavit filed by the respondents. I am reading in that paragraph.
Paragraph
4. May I read? Of this affidavit filed by the respondents.
1, 2, and 3. 1, 2, and 3.
1, 2, and 3.
In paragraph 4, what does it say?
4.
That regards him in paragraph 9 to 12.
Lordship, that answering deponent begs to state that the district school education officer, earlier designated as inspector school, is not not mandated to accord approval of promotion to the post of assistant headmistress. He is not authorized to pass approval order, hence approval accorded by the district school education officer to the resolution by which schools reveal to promote a teacher without BEd to the post of assistant is not legally valid. Yes. They said that it was director was not approved, it was approved by the district officer. But I am producing documents, Your Lordship.
What documents?
That it is earlier, Your Lordship.
It's part of the petition.
My reply, Your Lordship. My reply.
When you reply, you said?
It is filed on 20/10/2023. Reply affidavit, reply page 10, Your Lordship.
Reply affidavit.
Reply affidavit. Page 10.
Yes.
This is another student is sir, Sopikolog, the same school with the petitioner. He was promoted and it is approved by the director. And they said that it is earlier, we have submitted that some teachers are approved without.
But then again, see the second part of the. This is Dulal Das.
Dulal Das was misstating. Second part. I am reading.
This is.
Yes.
Publication of Sofikul Haq.
Sofikul Haq, it is approved by the director. Then Dulal Das case, yes, kindly verify your lordship. Second paragraph of.
No, director is fine. District school education officer is not the competent authority.
Not a competent. It is Sofikul Haq is approved by the director, your lordship.
Now you say, or they said that this is approved by the district.
No.
Yes.
Director. With reference to subject cited about that is
yes, from director to
director.
The district school education officer.
It is approved by director.
Yes.
This is my lord. The mic of my friends been switched off.
By whom?
My lord, probably by the court itself. Maybe it was echoing.
Yes. How do you say that 9 to 12? This at page 10. This is approved by the director of the rejoinder.
Yes, lordship. It is my lord, page. In fact, in page 9 of my affidavit in opposition also, I have annexed the approval letter of Dev Dulal Das. Why,
not
my
Dulal
lord?
Das, this other person.
Lord, I may just produce now. But the other person also is by the director. Sofikul Haq.
No, but the statements you made in your affidavit saying that you have said that at paragraph 4.
Yes, my lord. At paragraph 4, I have clearly stated as to why Shri Dev Dulal Das was his approval was
No, see
granted.
the first part of paragraph 4.
My lord, he is not authorized to pass such approval order and hence approval accorded by DSEO to the resolution by which schools resolve to promote teachers
Mr.
without
Islam saying
readmission.
that anyway we just
That is with regard to schools approving, schools resolving to promote teachers without
we'll have
DA.
to adjourn for a while. We'll continue everyone because I have some appointment I have to attend right now. If you wait, we'll recommence at 2 o'clock.
Lordship.
Okay.
Slightly.
Yes, Dr. Mosika, I have some difficulties.
But there are 2 matters left in the list, my lord. I have been invited for a court, my lord. So the matter
2 matters means?
Monday or Tuesday also, my lord.
Which matters are these?
The
Nigrim's
appointment matter.
That has to be taken up.
Monday, my lord. No, Monday you can take.
Monday is holiday. We take Tuesday as a fixed matter. That orders have to pass.
Can it be on a Wednesday?
Okay, Wednesday. That's fixed matter.
Item 34.
Which item is that? And the other matter with Mr. Marpan is online, my lord. That's item number.
Yes, sir. Item 31, your lordship.
31.
It's what's the matter?
Item.
This is also.
This is not a pension-related matter. The 89 to 99 clarification.
He went on deputation to Nigrim's, my lord, from state.
Yes.
So that 89 to 99.
So that can come on Tuesday or Wednesday.
As for the last order, it's some clarity.
Yes, you need some instructions.
I'll check it.
33.
After 1 week. 33 is the other matter.
Mine is 34, Your Lordship.
33 is whose?
33.
In 33, Your Lordship.
33 is which one?
After 2 weeks, Your Lordship, I paid.
What's the matter about?
Your Lordship, here we are challenging the order passed by the KHDC with regarding to the clan.
Regarding?
Regarding the clan, Your Lordship.
Clan?
Maunai clan.
Any urgency?
No.
Oh, Maunai clan. Okay, then the prayer also this after 1 week. Yes. We'll continue at 2:15. You'll be here? Yes.
Yes, Lordship.
Otherwise, you can have it on Tuesday if you want. You're from
As your
Shillong?
Lordship, please, my lord.
Oh, you've come
So
from
Mr.
outside?
Islam has gone from Guwahati.
2:15.